Well, going down the history as it relates to the major milestones relating to the justice sector generally, I think it is indeed a history of successes, and successes in that matter that could be attributed to collective action. Collective action in which the judiciary in its own right, the executive, and indeed the legislature were partners in progress as it relates to the recorded successes. How do I mean? Looking at the legislature, for example, it is indeed established facts that the legislature as an institution has indeed played vital and critical role in the successes that eventually are being recorded in the administration of justice. You have in place effective legislations that turns the fortune of the justice administration in the polity. If you are looking at it from the point of independence of the judiciary, constitutional amendment arising from the fourth alteration, which translated to the promulgation of Section 121, subsection 3 of the Constitution, has indeed provided the impetus for the independence of the judiciary at the state level, the independence of the legislature at the state level. So with the passing of Section 121, subsection 3 of the Constitution, the coast is now clear that the desired independence that is a necessary tool for dispensation, impartial dispensation of justice, has indeed been brought to bear in the justice sector administration in the country. Now, if you are talking of the executive, the fact that the bill as promulgated, as prepared by the legislature, was indeed assented by the executive, establishes the role of the executive in the advancement of the cause of justice as far as this country is concerned. And that has further been consolidated by bringing about instruments that will now eventually translate to effective and efficient independence and autonomy of the justice sector at the state level. How do I mean? His Excellency, the President, has indeed put in place Executive Order number 10, the spirit of which is in effect that the same thing that obtains at the federal level, whereby the funding of the judiciary at the federal level is indeed a first-line charge on the consolidated revenue of the government, will equally trickle down and translate to the same position at the state level, that judiciary at the state level will be beneficiary of a first-line charge on the consolidated revenue of state, thereby establishing in them the desired independence, the desired determination of their own fate as it relates to administration of justice, as it relates to the welfare of the judicial staff, as it relates to general impartiality, the general decision as it relates to the administration of justice. So in essence, you can see a picture has been successfully established by this administration, whereby the key components of the state, the executive, the legislature, and indeed the judiciary, are accorded the desired independence that is necessary for the art of deepening the democratic system as far as the Nigerian state is concerned. So in essence, it is indeed a journey that has seen that has brought about the desired independence, the desired autonomy, and indeed the desired expansion of the administration of justice within the spirit and the context of striking the balance as it relates to separation of powers.
All right, Minister, I will still stay with you. Of course, as Kingsley said, you are the chief law officer of the country. I would like to stay with you for a while. We just harped so much on the fact that there is the issue of autonomy, the judiciary and the judiciary at the state level. Even though governors are contesting that, but we'll move into that in the course of this conversation. But for now, I want to ask you a question concerning the desire of this administration to purge the judiciary of the bad element, whose misdemeanor is trying to, place a judiciary in the wrong side of the law. In fact, judiciary at a point was losing the age-long integrity, sanctity, and its neutrality in handling matters at that level. Now, what would you say this government has done in the last 5 years to ensure that this purging becomes effective and effectual as we go on as a nation?
Well, the major policy decision that has been taken by this government in ensuring the sustenance and indeed perhaps restoration of the integrity of the judicial system were multiple. But then among the major policy decisions that were taken, perhaps, was a decision that the executive is no longer operating a rubber stamp approach to judicial appointment, for that matter. Before now, the conventional practice as far as the appointment of judicial officers is concerned is somehow a one-sided affair, by which the NJC, Judicial Council, takes a decision, process and profile judicial officers, and submits them to the president for approval or confirmation. And the practice was for the president to take it hook and sinker. But for the first time, I think, in the history of Nigeria, a new policy decision is now brought to bear by the president, by which the executive organ of government, inclusive of the enforcement agencies, EFCC, ICPC, police, DSS, are accorded an opportunity, even after the processing of the names by the NJC. These agencies or institutions or enforcement agencies are accorded an opportunity of vetting the personalities that are presented for consideration. And I think an added consideration is equally brought to bear as it relates to legal compliances associated with appointment. For example, at a point, there were certain embarrassments that set into the system by which people that are legally not supposed to be appointed were indeed accommodated in the system, people that have not undergone the mandatory National Youth Service Scheme. So arising from those considerations, the need has arisen for agencies to be accommodated in the art of filtration, the filtering the judicial officers. And that has indeed fed off, because along the line, those appointments that were presented for consideration of the president were indeed vetted, and some were found not fitting and indeed dropped along the line. And that had indeed awakened the judiciary as a system to develop and enhance its in-house cleansing and filtration system. And we are seeing now and witnessing a situation and circumstances whereby the NJC is alive to its responsibility, imposing disciplinary sanctions where necessary, aging out those that are found befitting within the system, and that this, I think, is indeed paying off, which translated to the art of speedy determination of justice, to the art of speedy conviction of people with high-profile cases. Before now, we are living witnesses to the fact that there are cases in the system that had remained for over 10 years without moving an inch in terms of determination. But arising from this attitude of ensuring the integrity is collectively brought to bear between the judiciary and executive working together towards ensuring having a system in place that is indeed built on integrity, that is built on efficiency, we are indeed witnessing a tremendous changes both in the quality of input, in the quality of output as it relates to justice, administration of justice.
All right, learned senior advocate, just one last question for you in the meantime before we bring in the other guests, professors of law themselves. The rule of law is the foundation of democracy. How has the administration performed with regard to this?
Well, if you talk of a rule of law, it's not a rule that operates out of the blues. It is a process that is rooted in compliance first, and then in the spirit of compliance, operating within the dictates of the law and prevailing legislations as it relates to each and every item of consideration. For you to arrive at a decision as to whether indeed there exists a compliance with the rule of law within the context of governance, there are certain parameters that you need to bring into consideration. Is the government, in essence, giving effect to judgments and court orders? That is the first question. Within the context of giving effect to judgment and orders, is the government taking advantage of the judicial system by way of submitting to it when the need arises for challenging the judgment and orders that are handed down by the judiciary as an institution that is saddled with the responsibility of judicial determination of issues? So it is not a concept that you take in isolation, but a context, but a subject that you need to factor prevailing judicial, legislative, and associated components of rights that are built into the rule of law as a concept. So where, for example, a decision is taken by a court of law that the federal government should pay 10 million to persons that was said to have and a decision arriving perhaps to a breach of his human right, for example. The question is, must the federal government hook and sinker be submissive to the judgment? Or perhaps maybe the federal government in the circumstances reserve the right to appeal the decision? If taking into consideration the prevailing circumstances, constitutional and otherwise, that vest in you the power to appeal, that vest in you the power to apply for setting aside, that vest in you the power to apply for nullification of the judgment and order, the fact that there exists a breach of rule of law does not arise, because the same rule of law that now supports the sustenance of a judgment of the court vests in you as a government the power to appeal, the power to vary the terms of the judgment, the power to set aside the judgment. And until such time when the process is effectively consummated up to the Supreme Court level, it will be premature, it will be wrong, and indeed out of place for a conclusion that the government is not indeed a government that complies with the rule of law. So what am I trying to say in essence? The rule of law is a component of legality embedded in constitutionality, embedded in statutory and prevailing legislations that sees to the accommodation of the rights embedded within the context of the law. So once there exists a judgment, it does not mean to say that the government must indeed wholeheartedly, unconditionally give effect to the judgment, if it indeed desires to give effect to the statutory, constitutional, and legal rights that are vested in it within the context of appeal, within the context of setting aside, and within the context of challenging the decision.